Thank you. Well, I guess the air conditioning is working today. Our new chairs are supposed to be delivered this week. Yeah. Is anybody too cold? Speak for yourself. I'm ready to turn my heater on. Okay, is there anybody else supposed to be coming? Okay, well, we're still a little bit early. Well, we may as well get started. Anybody else comes? Oh, I thought we fixed that. Okay. All right, it's 9:30. All right. Good morning. I'm Charlotte Lane, Chairman of the Public Service Commission of West Virginia. With me are Commissioner Renee Larrick and Commissioner William Rainey. We are here today to conduct an evidentiary hearing in case number 220934, 220052, 230037, and 220535. First, Lashmeet Public Service District. On April 14, 2023, the Commission issued an order that reopened the certificate proceeding, rescinded approval of a customer surcharge, ordered modifications to an operation and maintenance agreement between Lashmeet PSD and West Virginia American Water Company, and required West Virginia American Water to pay a use fee. In the Certificate of Convenience and Necessity, Lashmeet PSD sought a certificate to design, finance, construct, and acquire a water line extension project to serve Mary Branch. New Haven PSD. On April 14, 2023, the Commission issued an order that reopened the certificate proceeding, rescinded approval of a customer surcharge, ordered modifications to the O&M agreement between New Haven and West Virginia American Water, and required a use fee to be paid by West Virginia American Water. In the CN case, New Haven PSD sought to construct a potable water line extension serving residents on Sunday Road, Confluence, Elliott Cutoff Road, Stringtown Addition Number 1, and Cliffy Addition in Fayette County. On May 24, 2023, West Virginia American Water filed a petition for reconsideration in the 4 cases listed above and requested that the Commission reconsider the April 14, 2023 orders in the cases to the extent that they disapprove the customer surcharges that were previously approved for Lashmeet PSD and New Haven PSD, and impose on West Virginia American Water an obligation to pay use fees to the district's funding agencies. The purpose of today's hearing is to hear evidence from the parties regarding West Virginia American Water's petition for reconsideration and the issue of the West Virginia American Water Company's obligation to pay use fees. In other words, we're here today for West Virginia American Water to tell the Commission why we were wrong in our order and to explain it in detail. So at this time, let's take appearances of the parties. Lashmeet, New Haven. Okay, do you want to stand up and tell us your names, please, so the court reporter, and you're welcome to come up here and sit. Maybe. If you can follow the instructions on how to use these stupid things. Okay, thank you. Welcome to the commission. West Virginia American Water.
Yes, thank you, Madam Chairman. My name is Chris Callis. I'm with the law firm of Jackson Kelly in Charleston. I'm here representing West Virginia American Water Company. With me is Rob Passmore, Vice President and General Counsel of the company.
Staff.
Good morning, Chairman, Commissioners. My name is Lucas Head. I'm here on behalf of Public Service Commission staff. And I have with me as a witness today Roger Eastep with the Commission's Utilities Division.
Okay, thank you. So everyone please check your cell phones to make sure they're turned off. And when you're speaking, speak directly into the microphone and make sure that the blue light is on before you start speaking. At this time, we will admit all pre-filed testimony into the record. And so let's begin the evidentiary hearing unless there's anything to come before the commission before we start. If not, Lashmeet, you may call your first witness. Okay. So the order of witness was Lashmeet and then New Haven.
I don't believe, Your Honor, that was the witness order that we filed last week. My understanding is that Lashmeet did not have any witnesses, that New Haven has one witness, Mr. Altizer, as the party, I suppose, bearing the burden of proof. In this case on reconsideration, we had the two water company witnesses going first, with Mr. Chrislip being the first of those, then Dr. Chard, then Mr. Altizer, then the staff witness.
Okay, so Lashmeet, you weren't going to testify? Oh, I'm sorry. Okay. So you weren't planning to testify?
Well, I submitted a written testimony through our attorney, Philip Tissue. It should be at the PSC. It's in the file.
Okay, thank you. Okay, so who's the first witness?
Mr. Chrislip is the first witness.
Okay, thank
Call
you.
him to the stand. Mr. Chrislip, if you could pull the microphone right up to you, I'll do the same. We'll get started. Please give your name and business address.
My name is Brooks Chrislip. I'm the Director of Business Development for West Virginia American Water at 1600 Pennsylvania Avenue in Charleston.
In that capacity for the company, have you caused to be prepared direct and rebuttal testimony on reconsideration in this case?
I have.
Do you have copies of that in front of you?
I do.
Yeah. Are there any changes or corrections you believe need to be made to that testimony today?
There are not.
If I asked all the same questions, would the answers be the same?
They would be.
Do you ask the commission to accept this as your sworn testimony in this case?
I do.
Your Honor, offer the witness for cross.
Staff?
Staff has no questions for this witness, Your Honor.
Commissioner Larrick.
I have no questions.
Commissioner Rainey.
No, Madam Chairman, I have no questions.
Mr. Crislip, would you summarize exactly what you think, where you think the commission made a mistake in what we ordered and why the use fee is not appropriate and should have a surcharge?
Sure, and the challenge with public-private partnership extensions that we participate in, and I think really a difference between these mechanisms and what we would do for a regular capital investment is these are not projects or really decisions that are initiated by the company. These are generally driven by the engineering firms and the public partners bring these to us, and we generally have not very little involvement other than awareness of what the project is. We review the design to make sure it complies with our engineering standards, and then we make the private contribution. And that's essentially the extent of our involvement. So the impact here is that we don't have the ability to really make a determination from a business standpoint as to whether these are really prudent investments, whether this is a good per customer investment. We are generally obligated, and from a policy standpoint, I think it's obviously good to extend water service to areas that may not have it. However, sometimes the costs on these projects can get exorbitant. We're starting to see projects that are well over $100,000 per customer, and that's for the total cost. And then our contribution is a percentage of that. So the challenge is when we're not initiating the decision making on these projects, there may be not projects that we would do and that are in the best interest of our customers. So effectively what happens with a use fee being imposed is the public partner would now have the ability to essentially say West Virginia American Water customers are going to have to pay more for this particular project that will serve a small percentage of customers in an area. That removes that ability, from us to have oversight on that. Secondly, we end up kind of functioning in that regard as a granting or lending agency in our own, and that we are having to pay the fees associated with debt service, and that's a challenge to our customer base as well because we are not a granting agency. So at a high level, that's our main concerns with the use fee.
Does the commission's approach to these two cases jeopardize West Virginia American Water's ability or interest in continuing public-private partnerships?
I'd say there's certainly that potential. I think with all business decisions and all public-private partnerships, there's certainly a tipping point wherein the company would have to really examine the details of a project and say, this is not economically feasible, it's not a reasonable expense, and it's not good for our customers to have to make this potential investment. So there could certainly be cases wherein that would be a challenge. And I think that's really why we want to bring this back to the commission's consideration, is the impact that could have on not just these projects, but future projects as well. And that we will inevitably hit one if there are not these guardrails in place that the current system has, where we're not able to participate. And that could be a challenge. And I think it's probably not the policy outcome that anyone wants to see.
Does the company have any suggestion other than a use fee or a surcharge?
Yeah, there are modifications to the O&M agreement we can make. I know that one of the issues raised by staff was concern about erosion, and the commission agreed with, I believe, erosion of potential customers on these potential for the districts. That is certainly something that we could modify O&M agreements going forward, so that concern is removed, so that any new customers that come on would stay with the district. Another modification that we could look at is maybe expanding the districts and the customers who would be eligible for a surcharge, which would greatly lessen the overall impact. So it could be a matter of a few dollars here or there if it's spread out amongst a bigger district customer base as opposed to just direct customers that are impacted. So those are a couple changes that we would be willing to entertain that I think would help alleviate some of these concerns greatly.
Okay, thank you. Mr. Callis, do you have any redirect?
No redirect, Your Honor.
Okay, thank you. Do you want to call your next witness? Thank you, Mr. Crislip.
Thank you.
Yes, the company would call Dr. Christina Chard.
I do.
Dr. Chard, please provide your name and business address.
It's Christina Chard, 1600 Pennsylvania Avenue, Charleston, West Virginia.
Dr. Chard, how are you employed?
I am employed by the American Water Services Company, primarily providing support to West Virginia American Water as the Director of Rates and Regulatory Support.
In that capacity, have you caused to be prepared direct and rebuttal testimony in this case?
I have.
Do you have a copy of that in front of you?
I do.
Are there any corrections or changes that you believe need to be made to make it truthful and accurate today?
No.
If I ask you the same questions today, would your answers be the same?
Yes.
Do you ask that the commission accept this direct and rebuttal testimony as your sworn testimony in this case?
I do.
With that, Your Honor, I offer Dr. Chard for cross.
Mr. Head.
No questions, Your Honor.
Commissioner Larrick. Commissioner Rainey.
Morning, Dr. Chard.
Good morning.
Help me out here. Put it in fifth grade language as to what the preference of the water company is as it regards these two cases.
The preference for the water company, whenever there's any sort of a construction project to provide service to our existing customers, first and foremost, making sure that we're covering the cost of service for those and protecting rate pressures that could come about. We do this internally ourselves, looking at investments that we're choosing to make, making sure that they meet those benchmarks of being prudent and reasonable, as Mr. Crislip had discussed a second ago. In this case, we're looking at not just these two entities, but potential for any PSD to come forth with projects that they may have. There has always been a protection in place, or a limit, if you will, or guardrails that have limited the amount per customer, so that reasonability factor for the company to invest in providing service to unserved or underserved areas. That is our Rule 7.4, 7.5 investment, about $6,000 per water customer and about $5,000 for wastewater. In this case, and even in others that we've seen documented throughout these procedures, there are more and more of these that are going to come about. And to order the company to pay more than that, what has been defined as reasonable previously through this Rule 7.5, then calls into question, well, what is the limit? These are customers, or we have existing customers that we're trying to protect rate pressure wise. There doesn't appear to be controls or limits on what's being asked. Now, there is in this case because it's defined, right? But the cases that we see on the forefront can be anywhere upwards of over $100,000 per individual to provide service in those areas. That calls in the reasonability and the prudency of investment for these areas, especially given how the company goes about and has control over its own investments that it's making. But in this case, these are not customers yet, right? So our existing customers are being asked to cover the investment to make these individuals customers. And I know Mr. Eastup had discussed single tariff pricing. I have discussed single tariff pricing. Single tariff pricing is good to help a company be able to cover its cost of service amongst its existing customer base. And we're not talking about existing customer investment at this point. We're talking about customers that aren't customers yet, and looking at the prudency of that. When we look at the need to be able to protect rate pressure, again, I keep going back to that. That's something that we consistently look at. The company, without having the controls in place that Mr. Crislip, or the oversight that Mr. Crislip had discussed for these types of projects, the company has concern about the precedent being set in this case.
Good. Well, thank you. Can this be done through the O&M agreements, do you feel like, or is it, and then reflecting a commission order that would accept an amended O&M agreement?
Well, and that's a good point, because one of the other items that we have concern with is the fact that we're not making the capital investment in these projects over and above our contribution. We're making an expense. The order was for us to cover expense to make a debt payment for another entity. When we look at O&M within our company, we try to minimize that. We try to make sure that it's efficient, that it's carefully monitored and controlled, because O&M, if you look at customer rates, $1 of rate revenue on an O&M side is purely just a recovery of $1 for that expense. So while the commission in this order had described the ability for the company to recover dollar for dollar for the expense that we would be making in these cases, if you look at rate making and you look at a rate revenue dollar, the existing customers benefit more from us investing capital, which if you look at $1 of rate revenue, that can give me either $1 of expense, or it can give me about $8 of capital investment money to go back into the infrastructure. So that in and of itself is also what we have heartache with, is that when we're looking at what our customers are paying for dollar, they get more benefit by having capital investment than they do OpEx. And then there's even the capitalization piece of it that comes with depreciation expense, which allows, once a depreciation expense is authorized, that can then be used, as it currently is in the DISIC case, to help fund future investment as it's deemed internally generated funds. So just simply modifying the O&M agreement to meet what the commission is asking still doesn't get to the root of the issue about not having controls and the best use of the customer dollars.
Thank you, ma'am. Thank you, Madam
You're welcome.
Chairman.
Thank you, Dr. Chard. You may as well settle back here for a while, because I have a whole list of questions for you, 7 pages.
Okay.
There are arguments in the West Virginia American testimony that the O&M agreement approach allows the public companies to qualify for favorable financing for capital projects while still getting the benefit of the West Virginia American expertise in operating water utility systems. However, the argument points out that the public entity would have no incentive to seek the lowest cost financing if the debt service is fully covered by a fee paid by West Virginia American Water. Does that fairly describe the concern about incentivizing or decentivizing the public entity to seek the lowest cost financing available?
That is a concern of the company as well, because if this now becomes an option for West Virginia American Water to incur expense to cover debt payments for unfunded portions of these projects, and I forgot where I was going with it. to cover unfunded expenses of these projects, that may disincentivize other public service districts from having to, if you will, work as hard to get the public funding available, rather than just having the water company to pick up the portions that they cannot fund. And again, there's no controls or limits that have been defined.
Isn't the reasonableness of the financing something that the commission reviews in a certificate proceeding, and can't the commission require proof that the public entity sought the most favorable financing available?
I'm not sure of the specifics of, I assume they would all have to file certificate of necessity procedures with the case. If that is the case, then yes, the commission does get oversight on the reasonable and prudency of the project in itself.
If the public entity in a public-private partnership with West Virginia American Water was so small that a financing package for extending service to new customers would cost its customers $100 per month surcharge, are you suggesting that the commission should allow that surcharge, or in the alternative, deny certificating a project that will get good, safe water to scores or perhaps hundreds of customers?
I would not even attempt to suggest what the commission should decide in those cases.
If the Lashmeet or New Haven systems were owned by West Virginia American Water and the projects under construction to extend service were needed to get service to those customers, is it your position that West Virginia American should simply refuse to provide service unless the small number of new customers paid the construction cost above our Rule 5.5 limit in full and in advance?
So we do this every day. If we have existing customer bases, we have areas that could benefit by having water service provided through main extension projects. The company has to look at that and weigh that need with the need of its existing customers, the need to replace infrastructure, the need to meet regulatory requirements that are being handed down, such as lead service line requirements and cryptosporidium requirements and so forth. So the company would have that full picture to be able to look at all of the needs to be able to continue providing service to its existing customer base before it could determine whether this new main extension project is reasonable and prudent at this time.
When West Virginia American adds rate base to improve its system and also adds new customers, are the rate base costs paid by West Virginia American customers and district customers in districts that have that kind of O&M agreement we are considering in these cases?
Could you restate that question?
When West Virginia American adds rate base to improve its system and also adds new customers, are the rate base costs paid by all West Virginia American customers and district customers in districts that have the kind of O&M agreement that we are considering in this case?
Any investment that the company makes does become part of rate base for, and I say investment, I mean capital investment. It does become part of the cost of service, which is then spread across the company's customer base. And because there are O&M agreements in place for these district customers, they also get the rates that the existing customer base have.
If the commission decides to agree with your proposal, that would result in only the customers of the districts paying the financing costs for extending service to unserved areas. Is that correct?
That is correct. I would also state that it is the district that chooses to go forth with these projects, and it's the customers that sign up knowing that that surcharge can be there, but they are willing and wanting to proceed with those projects to get service regardless of that surcharge that they're facing. So it's voluntary.
If the district customers are the only source of revenue to finance distribution lines to provide service to unserved areas near the district existing lines, in other words, pay their own way for distribution lines, then instead of the full West Virginia American rates, why shouldn't they pay a base tariff rate that removes the distribution line rate-based cost incurred by West Virginia American to serve the West Virginia American customers and to extend service to new customers?
Again, the customers that are paying the rates, the company standard rates, are existing customers. And that's the distinction that I have here is individuals that are not customers yet, we're looking to determine if we're going to add those customers, is that project prudent and reasonable, versus we've got our existing customer base, there's a cost of service for them, and we do have single tariff pricing, so that cost gets spread across all of that existing customer base.
In the New Haven agreement, there are many references to new district customers. The term new district customers is defined as approximately 55 residential customers, each of which have executed a user agreement to accept water service. To understand the terms of this agreement, are new district customers limited to exactly 55 residential customers that have executed a user agreement?
I would say it's not limited to that, but I would also say that that doesn't always come to fruition as well. We get folks that sign the user agreements, and then when it comes time for the actual project for them to tap onto the lines, not all of them do.
And to expand on that, if additional customers have signed user agreements or may sign a user agreement in the future, are they considered as new district customers for purposes of this agreement?
Yes.
In case number 220535, the certificate case, which is the certificate case for New Haven Sunday Road project, the notice of filing and the health department funding letters refer to potentially 67 customers. Are the other 12 customers still potential customers, or have any of them signed service agreements?
I'm not sure where they stand in that process, but if they would sign, they would be considered district customers.
In the O&M agreements filed in this case on page 2 of the agreement, which is Bates page 8 of the filing, specifically refers to a contribution from West Virginia American of $338,415, or $6,153 times 55 residential or residential equivalent customers. But it further refers to an amount based on the current number of new district customers who have signed user agreements prior to the district's filing for a certificate of public convenience and necessity with the commission. If there were only 55 signed user agreements when case number 220535 was filed in June 2022, is it the intention of the parties that the West Virginia American contribution is capped at an amount based on 55 customers, even if there are more customer agreements?
No, it's actually very typical for us if we get a customer count when it's time to make that contribution. For those that have signed up for user agreements, whatever that number is, we pay that per customer contribution rate.
In section 4C of the O&M agreement, which starts on Bates page number 12 of the agreement, the term, in quotes, unit of property is used. The agreement states that a unit of property is defined as such terms as defined in the Uniform System of Accounts of the National Association of Regulatory Utility Commissioners. We do not believe that specific units of property are defined in the system of accounts. However, it refers to and describes how retirement units are to be determined. When you refer to a unit of property in the O&M agreement, do you mean retirement unit?
I actually need to see that. I don't have that in front of me, the O&M agreement, to understand the context of it. specifically whether we're talking about company investment units of property or the districts.
Dr. Chard, I don't know that I have that with me. Perhaps staff does.
The O&M agreement.
It may, although I'll say that that's not a joint application that that the company was involved with. Well, yeah, maybe it would have been. This is for New Haven. Yeah, I can help you with that. Yes.
And what page, Chairman? Was that page 7? Or that might have been a previous question.
Bates, page 12.
12. My Bates page 12 is a section title page.
On New Haven,
This is Lashmeet.
I think we're still talking about New Haven.
Okay. It should be in the Lashmeet somewhere.
It's case number 220535.
Do you have reference to the actual page number for that O&M agreement?
No.
No. Did you have what section title that would have been?
No.
I'm looking here. No, it looks like this one's just Lashmeet. But there is a section called replacement of unit of property, ownership of units of property. And what you quoted talking about NARUC could potentially be that replacement unit of property section.
And that's what I was asking. When you say unit of property, are you talking really about retirement unit?
I'm talking about unit of property. I view that as an asset. So if we made an investment or the district made an investment, again, a capital investment, that investment is being made to build an asset. So units of property being assets. And that can be mains, that can be meters, services. Those are units of property that this would relate to.
Okay, let's move on. The Uniform System of Accounts contains the following accounting instruction: utility plant additions and retirements. For the purpose of avoiding undue refinement in accounting for additions to and retirements and replacement of utility plant, all property shall be considered as consisting of 1. Retirement units, and 2. Minor items of property. Each utility shall use such list of retirement units as is in use by it at the effective date hereof, or as may be prescribed by the Commission, with the option, however, of using smaller units provided the utilities practice in this respect is consistent. The Commission has attempted several times to get the present and prior lists of retirement units used by West Virginia American Water, or a statement that you are not maintaining such list of retirement units as required by the Uniform System of Accounts. However, I do not believe that you have filed the list or the statement that was requested in the Jefferson Utilities case. If you have, just direct us to that filing. If you have not complied with the request in the Jefferson utility case, please, in this case, file your current list of retirement units or a clear statement that you do not maintain such a list.
Okay. So the company's, where do I start? So the company is going to file a list of retirements in the Jefferson Utilities case. It is one of the items that we have to file after close, so we are going to provide that. It is an ever-changing list as we have assets that come end of life, and we retire those assets or units of property. The list is ever changing. Those are identified and they're run through the accounting system so that we properly retire those units. So it will be provided.
If Section 4C of the O&M agreement applies in the future, how will it be determined that the company has replaced units of property that are considered to be plant in service owned and depreciated by West Virginia American Water?
How will the commission determine what?
How will it be determined that the company has replaced units of property that are considered to be plant in service owned and depreciated by West Virginia American Water?
We would have records of that.
When did New Haven first enter into an O&M agreement with West Virginia American Water?
I do not have that in front of me.
At the time immediately before the first O&M agreement with West Virginia American Water, how many customers did New Haven have?
I do not have that information.
Do you know how many customers
Unless
today?
it was in one of the DRs.
You know how many customers?
Yeah, 1 second. Actually, it is in one of the discovery requests. And you said New Haven?
Yes.
So I have, as far back as 2013, that New Haven PSD had 1,862 customers. And in 2023, they have 1,976 customers.
When did Lashmeet first enter into an O&M agreement with West Virginia American Water?
I do not have that. Well, wait a minute. It might be here. Hold on. No, I just have the amended O&M agreement. I don't have that information.
Do you know how many customers Lashmeet had before the first O&M agreement?
I do not. I do not.
Do you know how many customers they have now?
Lashmeet. Lashmeet, just for frame of reference here, in 2013 had 1,565 customers, and in 2023 had 1,672 customers.
Under the agreements, do the districts install the utility service lines on the new facilities to serve the new district customers that sign service agreements?
The district manages the projects with the funding, and even West Virginia American Water's contribution, and I'm not going to speak out of turn because I don't know exactly, but I believe our contribution usually goes towards not the mains, but the services, meters, hydrants, and so forth. But I don't want to misspeak on that, so I do not know completely.
After the districts have completed construction of the project, If there is a new application for service on the project lines, does West Virginia American install the utility service lines to serve the customer?
If there's a request for a new customer to be added to the existing mains?
Yes.
I believe so.
If a new customer applies for service and West Virginia American installs the utility service line that is on the same side of the road as the main line, and it extends only a very short distance to connect with the meter and the customer service line, will that new customer be considered a customer of the district and subject to the district debt service surcharge?
Yes, as the company had responded to in the discovery request, the company considers any customers within the service territory of the district to be district customers.
If a new customer applies for service and West Virginia American installs the utility service line that ends on the opposite side of the road as the main line, and it must extend the utility service line 20 or 30 feet under the road to connect to it, will that new customer be considered a customer of the district, or will that customer be a customer of West Virginia American Water?
If that customer resides in the district's service territory, that customer will be a district customer.
If a line extension to serve new customers is requested in the future, does the O&M agreement allow the district to make that extension and serve the new customers on the extension as district customers?
I don't know in that particular instance specifically what's defined in the O&M agreement. But just like we have main extension projects, if there is investment that is made and it's within that service territory of the district, they would be considered district customers. And yeah, I couldn't comment further because I don't know the specifics of the agreement.
If a large section of district main line is damaged or deteriorated for any reason and it has to be replaced at a considerable cost, is the replacement the responsibility of West Virginia American Water pursuant to the terms of the O&M agreement, and will West Virginia American own the portion of the line that was replaced?
Yes and yes.
If a large section of district main is damaged or deteriorated for any reason and it has to be replaced at a considerable cost, and under the agreement West Virginia American owns the portion of the line that was replaced, when district customers are reconnected to the West Virginia American replacement line, are they still district customers?
Yes.
Can I have some questions about a response to a staff interrogatory? It was filed on August 17, 2023, with the engineers coming from Mr. Ramo, Director of Engineering. In response to the staff question about DISIC qualified investments, Mr. Ramo identified the following projects: Old Lashmeet Road, 200 feet, Reese Harmon Ridge, 4,700 feet, Reese Harmon Phase 2, 7,400 feet, Rich Creek Road, 3,800 feet, and Cottontail Road, 1,740 feet. I have the same questions about each of these projects. The Old Lashmeet Road project replaced 200 feet of 6-inch pipe at a cost of $133,000. Were there pre-existing district customers connected to the 200 feet line that was replaced, and if so, were they reconnected as district customers?
The company has described, I was just trying to find whether it was in testimony or the DRs, the fact that we do not maintain customers, customer counts outside of, here's the district's service territory, these are district customers. So to the extent that any of these investments are within the district service territory, those customers would remain district customers.
Since that job was completed, have there been any new customers directly connected to the new pipe?
I don't know that answer.
Okay. The Reese Harmon Ridge project replaced 4,700 feet of 8-inch pipe at a cost of nearly $1 million. Were there pre-existing district customers connected to the 4,700 feet of pipe that was replaced? And if so, were they reconnected as district customers?
To the extent that that project exists within the district service territory, those customers would remain district customers.
And so when the job is completed, if it's within the district, they're district customers?
Yes.
Okay, Reese Harmon Phase 2 replaced 7,400 feet of 6-inch pipe at a cost of nearly $1 million. Were there pre-existing district customers connected to the 7,400 feet of pipe that was replaced? And if so, were they reconnected as district customers?
If the project was in the district service territory, then the customers would remain the district customers.
So the same answer is on Rich Creek, Cottontail, and Pin Oak, that if the replacement is within the district, those people that are on those lines are district customers.
Correct.
Here, I just skipped the whole page. So I'll ask you the same question I asked Mr. Crislip. So West Virginia American Water is saying that we were wrong in doing the use fee instead of a surcharge. And so is that approach going to adversely affect West Virginia American Water's ability to enter into public-private partnerships in the future?
I would say that it depends. It depends on how much we're talking about. One of the big concerns that we have is that there are no limits to this for future districts that might come forth with additional projects. One other item that I didn't mention either was the characterization of this as a use fee. Use fee is typically used when you've got an entity that is leasing assets of another entity, and that's the use fee for it. Whereas this is not the case. This is expense that the company is being asked to make to cover debt payments on behalf of another entity for them to build assets. So, is the potential there for it to become an issue for the company to continue these types of projects? It's there, but it depends how much, how large are these going to get? How unreasonable could they potentially get? Is it, are we facing for example, our contribution rate of $6,000 per customer capital investment versus maybe $100,000 or $200,000 of O&M expense to cover debt payments for other entities to build assets. So it depends. But there is a potential there if they add up over time. It's a lot of rate pressure on our existing customer base, given that there are other capital projects the company could be investing in that would give existing customers more benefit.
So if it's not a use fee, how would you characterize it?
It's characterized more of a concession fee.
A what?
A concession fee is more typical in O&M agreements when they're not rental of assets or leasing of assets. And that's an accounting term, phrase for it.
Thought it was ice cream or something, concession. Okay, so if the company thinks that the commission needs to revise its approach, is there another alternative between this concession fee and the surcharge?
So the concession fee is what the company has most issue, especially without any guardrails, any cap on this type of expense that the company could potentially have to make over time. These are long-term expenses too. These are 30 years, 40 years. Just these two, we're looking at $20,000 a month of expense. You multiply that times 8, I could be using those rate revenue dollars for a lot more of capital investment to replace aging infrastructure and so forth. The surcharge, we look at that as that's a surcharge that the district has voluntarily agreed to, that the customers that have signed up for water to be provided to them have agreed to through their customer usage agreements. It is a district managed project, and again, it's all voluntary investment that they are choosing to be part of, and to have the existing customers of the company cover that as expense, not capital investment, as expense, has more of a rate burden on the customers than a project that we may fund ourselves, that our existing customers could benefit more from. So our recommendation would be to go the surcharge route, because the district and even the IJDC and all of the other parties that have been involved in providing funding for the project, in their eyes, have viewed the project as a feasible project to move forward with, and they have calculated these surcharges. Customers have agreed to it. Potential future customers have agreed to it, and that's where the charge should lie, to cover that cost of service. If these customers ultimately become customers of the company through an acquisition 40 years down the road, then they would become part of West Virginia American's base cost of service. If the commission would stick with the order and have the company pay O&M expense to cover the debt, the unfunded portion of debt for these projects, the company does request that it be managed, it be monitored, that, for example, the commission has advised that they would provide recovery for this expense under the DSIC mechanism. We would ask that that line item be part of the DSIC until it expires, so that there is a line item on the DSIC, identifies it as PPP expense, and it's monitored as it accumulates. And as the potential for other districts to come forth with similar situations that the commission may approve, we're constantly monitoring that rate pressure on our existing customers. And we would also ask that that not be part of the DSIC capital, the DSIC cap that we have in our existing infrastructure, and that there also be some limit placed on that, like an annual limit, for example, for these types of expenses that the company is being required to make.
Okay, so you're going to have to refresh my memory. Let's take Lashmeet. I think you had asked for a surcharge of $4.40, and is that usage based, or is it just customer based?
I'm not sure which one you're referencing. That the district had maybe requested?
I think what I think the district may have requested a $4.40 surcharge, and then staff recommended that it be $2 and something, and I think that's what the ALJ approved.
Okay. I think that was the one where it was split between the $2.50 surcharge being implemented for the district customers, and then the remaining portion of it, which is I think it's going to be around 280,000. The company would cover instead of surcharging the full amount that was proposed initially.
Okay, so my question is, do the Lashmeet customers then, under the surcharge proposal, pay the Lashmeet rates plus the surcharge?
They would pay the Lashmeet rates, which according to the O&M agreement would mirror the company standard rates, and they would pay the surcharge.
So the Lashmeet customers will be paying the West Virginia American Water rate plus the surcharge.
Yes.
And is that true of the New Haven customers?
I don't know that New Haven has had a surcharge that's been approved, but I just can't recall at the moment. But it would be a similar situation if there was one.
So Lashmeet and New Haven will be paying the West Virginia American Water rates.
Once they become customers, yes.
Okay, that's where I'm getting confused. When do they become customers?
When the project is complete, then they become customers. The construction project.
Okay, thank you. Mr. Callis, do you have any redirect?
I do have a few, Your Honor. Thank you. Dr. Chard, Chairman Lane asked you a question about whether districts in the future would have to get CN orders in order to do projects like the ones we're talking about here. And wouldn't there, in that situation, be an opportunity for the commission to look at the feasibility of the project, how much it costs, cost per customer, funding arrangements? And I think you said yes, that's a possible outcome. Do you agree?
Yes.
There would be, as there is now, a lot of pressure, though, to approve projects that are intended to serve people who don't have water service now. Do you agree?
Yes.
In fact, you know, it's the same kind of pressure that you know, drives counties and their public service districts to come up with these extension plans that we end up becoming a part of when they ask for a contribution, right?
Correct.
It's always very popular to extend water to people who don't have it, no matter how much it really costs.
Yes.
And the surcharge has played a role along with the IJDC in being a set of guardrails on how much cost per customer for a project is appropriate and how much is too much.
Yes.
And in fact, the Public Service Commission sits on that board and makes those very decisions based in part on cost of service per customer.
Yes.
Commissioner Lane also asked you to assume that, I think this was the gist of the question, that instead of Lashmeet being a PSD seeking to serve additional customers, that it was the water company's territory. And we were the utility who had received the request from people outside where we serve to get service. And she asked, could the water company simply refuse to extend service to those customers? And I think the implication of the question was, if it were more than our contribution based on 7.5 to a single customer or a group of customers. Could, in fact, the company refuse on that basis? That it was only going to pay the 7.5 dictated amount?
Yes.
In fact, that's what the rule requires, isn't it?
Yes.
It's not a decision that the company makes. There are water rules that govern us and all other utilities that say that for the benefit of existing customers, there needs to be a reasonable relationship between what you invest to extend service to a new customer and what existing customers are going to have to bear in their rates.
Correct.
That's the whole reason we have Rule 7.5.
Yes.
And it's been on the books for years and years and years.
Over 20 years.
Yes. So, and it applies not only to the company, but to all other utilities, public and private.
Correct.
So, in the situation that Chairman Lay posited for you, not only would we need to refuse, but the rule would require us to refuse. And then we would say, this group of customers, here's how much you would have to pay in excess of our contribution in order for us to run the extension.
Yes.
And if the hypothetical was not us, but was Morgantown Utility Board, municipal utility, it would do the same thing, right?
I would believe so, yes.
As a municipal, instead of a investor-owned utility, its contribution amount is calculated somewhat differently under Rule 7.5, isn't it?
Yes.
But the premise is the same.
Yes.
How much revenue is each one of these new customers going to generate in the future, and that's how you base what your contribution is going to be.
Correct.
And that's the same whether MUB is extending service to a single customer or to a group of 100 customers.
Correct.
Or to a new manufacturing facility.
Yes.
Or to a developer who has a tract that he wants to build 100 homes on.
Yes.
It's all the same.
Yes.
You calculate the revenue, you say, we'll pay this much, you have to pay the rest.
Right.
Okay. And in each of those situations, if there is an amount above the Rule 7.5 contribution, the party that wants a water, be it a single person or 100 people, or a manufacturing facility or a housing developer proponent, they all would have to come up in some way with that additional amount.
Correct.
And they might do it by, for example, the developer might add a certain cost into the amount that it sells its lots for to pay for that.
Yes.
Or a group of customers who wanted service from Morgantown Utility Board, let's say, could borrow money and agree that they would pay it off over some number of years and pay that up front to MUB so that MUB could make the extension.
Correct.
And is it not the case that in those situations, be it a single person or a group of people or a housing developer or a manufacturing facility, that they are all coming up with money to give the utility, and they are going to pay the cost of borrowing that money over time outside of the cost of what the water's going to cost when they eventually get it?
Yes.
Okay. And is it also true that that arrangement of borrowing money is not dissimilar to the surcharges that these districts, in this case, have agreed to pay?
Correct.
So if the orders that the commission has issued in this case were adopted as what we go by in the future, there would only be one situation in West Virginia where a water utility would be required to pay more than a 7.5 contribution. And that would be a situation where the water company is involved, and where a public partner is involved, and where a public partner has an extension it wants to do.
Correct.
In every other situation that I've described, the entity that wants water service would have to pay the amount representing the difference between the total project cost and the 7.5 contribution.
Yes.
Is there any basis that you can see that the water company in this particular situation ought to be treated differently than all other water utilities under the same rule?
No.
Is there any reason that the company's customers, even though it's a large group of customers compared to other water utilities in the state, ought to be expected to front the additional costs of extensions beyond Rule 7.5 when all the other water utilities we've described would not have to?
There's not.
You answered a few questions about the DISIC, and in response to Chairman Lane's questionings, and you said, you thought it ought to be a line item on the bill as a public partner extension expense, and you said some things you'd like to see in the DISIC as controls. Is it also the case that if you had a continuing, not that this is the company's proposal, but if you had a continuing amount in the DISIC that related to debt service for public partners, when you came in for a base rate case, that amount would not go away and be folded into the company's rate base like it currently does?
Correct. We would request that that be a line item that would remain with the DISIC mechanism so that we are able to manage that total amount, that total expense more clearly through the DISIC mechanism.
Yes, but my point is we would have an amount that would continue in the DISIC and not zero out.
Correct.
Every time we went through a base rate case.
Yes.
And that would last, whatever the terms of the underlying agreements, the loan agreements would be, right?
Right.
Chairman Lane asked you a number of questions about retirement units, and it became clear to us in some of its orders in the JUI case that the commission is perplexed about retirement units and NARUC guidelines and what we've called a unit of property in these O&M agreements. Is it the case that this term unit of property and replacement of unit of property has been in O&M agreements for a long, long time?
Yes.
And we tend to carry it over
Yes.
from one agreement to the next. Is your understanding that the purpose of that provision is, or one of the purposes of that provision in the O&M agreements is to differentiate between segments of replacement property that the company would have an obligation to come in and install that are of a certain size where you can actually call them a piece of property you're going to capitalize, as opposed to smaller things, clamps and bands and other things that don't cost very much that you're not going to capitalize?
Correct.
That's one of the main purposes of that provision in the agreement.
Yes, and that the company would maintain record of investment in capital, units of property or assets that it is building versus what the district had invested initially.
You and Chairman Lane talked about the term use fee and how it in your view it typically relates to fee for a service that you're using. In fact, use fee has been the term that was used and still used in connection with the IDB transactions of the early 2000s, where we're actually paying an amount that represents foregone property taxes.
What were those initials?
IDB, Industrial Development Bond transactions.
Thank you.
Yes, thank you, Chairman. In the early 2000s, and the sense was that the company would be paying in amounts that happened to represent foregone property taxes to the districts for the use of their facilities. that would be constructed under their projects facilitated by the IDB arrangement. Is that how you understand it?
Correct, yes.
So there is an actual connection in that case between the company's use of someone else's facilities and the use fee term,
Yes, there is.
whereas there would not be that kind of connection in this situation.
Yeah, this PPP does not involve an industrial development bond or leasing of assets.
Is it the company's view that the need to pay a surcharge at the district customer level or potential customer level is a powerful incentive for?
Mr. Callis, are you testifying or are you redirect?
I'm redirecting, and it wouldn't be appropriate for me to testify, Your Honor.
Well, it sounds awfully close to testifying.
Maybe I'll ask this next question of the next witness.
Okay, thank you.
Yeah. Well, give me 1 second, if you will, and I'll see if I'm done. Thank you for the time, Your Honor. I appreciate it. I'm done.
I have a couple questions.
Okay.
If the districts are going to be paying the West Virginia American Water rates, then explain to me why single tariff pricing isn't appropriate in this case, these cases.
Let me refer back to a section of my testimony. The company's argument in this case is that the premise of single tariff pricing is based on there's the fact that there's a cost of service for your customer base, your existing customer base, and single tariff pricing allows rates to be set at the same rates for all of its customers. To ensure that there's economies of scale there, that you can invest capital in one area versus another, that you can incur expense in one area versus another, but you're looking at your closed system, if you will. Here's my customer base. Here are my expenses. Here's my capital investment that I've made. I have this many customers. When I assess that cost of service, of providing that service to those customers, then I'm setting the rates, spreading the rates or the cost of service across all of that customer base. In this instance, these are not customers of the company. These are potential customers, but they're not customers yet. And we're talking about investment expense that's being required to be made over and above capital investment that's been deemed reasonable through Rule 0.75 to bring those customers or to make those individuals customers of the district. But they're not yet customers. So it's it's a delineation between what's our existing cost of service, how many customers do we have that are receiving that cost of service, let's spread the rates across them, versus these are not customers yet.
So I have one more question.
Yes.
Having said all of that, then why shouldn't Lashmeet and New Haven pay their existing rates plus the surcharge?
Their existing rates are the standard company rates.
Right now?
Yes.
Okay. Okay, thank you.
Thank you. You're welcome.
Off the record, do you all want a break or should we go on? Okay, let's call our next witness.
Your Honor, the company is concluded as witnesses.
Okay, thank you. And our next witness is Mr. Altizer. Okay, do you want to come up here and be sworn in, sir?
Yes.
Do you want to summarize your testimony, please?
Yes, ma'am. My name's Billy David Altizer. I am, yes, again, the project manager for the New Haven, you all call it the Sunday Road Confluence, et cetera. The locals in the Public Service District calls this Contract 18, just so you all know. That's what we all go by. So I'm here to discuss that, and my concern is a singular concern. It's about the timing of the project. The people to be served by this project they asked for water 30 years ago. This issue that we're having with the surcharge versus the use fee, in my calculation, has delayed the project 9 months as of today. There's also another contract 19 for New Haven Public Service District that's just right on track with this one. It's been held also because of that. And then I'm also the project manager for 2 projects in Summers County that the same issue will apply. And it's at a 1 month delay by my calculations right now based on this issue. In other words, if the issue were resolved in the next 2 weeks and we can move forward, you'd see a 9 month delay at New Haven and a 1 month delay in Summers County. That's at Jumping Branch Nimitz Public Service District. So my question, I hate to say it's a question, but what I was hoping was there's some way that while this issue's been worked out, the projects could go ahead and move forward.
So it's not going forward now?
No, the commission issued a certificate of convention necessity November 2nd, 2022, with contingency that the O&M agreement be approved by the commission. And that's where all this started. So right now, we don't have permission to advertise to bid, even though it's ready to go. Everything is ready to go, except this issue has got all held up. And I just wondered if there's some way that, because either way it is resolved, the project's going to go. It was already on track to be moving forward under the surcharge mechanism. And of course, if it goes with the use fee mechanism, that's even better for the customers. And it's definitely go that way. So either way, it's a go from my perspective as a project manager. But the people are being delayed by these proceedings is kind of what I'm saying. So I don't know if y'all can figure out the way to just turn us loose, but that's what I'm here for, to see if that's possible to be done.
And you're representing New Haven
Yes, ma'am.
and Jumping Branch.
Yes, ma'am.
I thought the Jumping Branch issue was taken care of.
No, it's the same. They're not. We haven't applied to you all for a certificate yet for Jumping Branch, but it's on the same track. I mean, and you all even mentioned it in your order. The Jumping Branch was named in the order, even though it's not part of this case.
Okay, Mr. Callis, do you have questions?
Yes, Your Honor.
Hi.
How long have you worked with the district?
Are you asking about New Haven? Approximately 2 years, and I've got 2 contract 18, which is the subject of this hearing, and contract 19, and we've got 3 more extensions in the works.
Yes, that's what I wanted to ask.
Yes. Mhm.
Absent the commission's orders in April, which is why we're here, would each one of those be contemplating a surcharge as part of its contract?
I'm not sure I understand exactly what you're asking me. Until this came up, that's what the funding plan would have included. It's my understanding, yes.
Would it involve going out and paying customers? Because we would pay that surcharge to get one.
When we get user agreements signed, they normally don't ask and we don't tell them what the cost is going to be of the project. They just agree to pay the fee for 3 years if they get water, yes.
Do you believe that it is beneficial in the development projects to get as much grant and lower historic money as possible?
Yes.
That's one of the primary things that in the development of project engineers and districts and regional development authorities are working.
Is that a question? Yes, the answer is yes.
There is no not necessarily an obligation to get low interest loans and public funding. Though you could, if you had enough money as a district, go to a private bank and get a loan to pay for a project. Is that correct?
Maybe ask it again.
Yes, there's no obligation necessarily that, or nothing that precludes a district or someone doing a project to get private financing. Have you ever seen a private bank loan, say for a design loan or anything like that?
Okay, that's 2 questions.
Yes.
The first question, there is an obligation. The Infrastructure, Jobs, and Development Council reviews our funding plans, and we cannot go forward with the project unless they approve the plans, and then ultimately it goes to this body, and they have to approve them also. So we know that if we just say, okay, we're not going to try to get any grants at all, we're just going to go out and get a loan and let these people pay whatever it is, the answer is going to be no from IJDC and from the Public Service Commission.
But
And then
under the statutes that govern the IJDC and the rules, if you're not getting state provided funding, you don't need to go to the IJDC, do you? Maybe you don't know because you've never seen it happen.
That's the correct answer. I've never seen that.
In fact, that's the case. If a district knows that the company is going to pay all of its debt service, no matter what it happens to be, do you think it's going to be less inclined to go to the effort and expense and time needed to get a good public funding package to design and build a project?
You're kind of asking me questions about stuff that I'm not really here for.
It's okay if you say you don't know.
I didn't say I didn't know. I'm just saying that's not what I'm here to I'm just here to talk about the timing of it. Do you want me to go ahead and proceed, Chairman?
You can answer the question if you want to, or you can say you decline to answer it.
I want to decline that.
I have no more questions. Thank you.
Thank you.
Mr. Head,
I had some questions, but they were covered, so no questions. Thank you.
Commissioner Lyric. Commissioner Rainey. I have no further questions. Thank you.
Thank you.
So, Mr. Head, you ready to call your witness?
Yes, thank you. Staff would call Roger Eastep to the stand.
Yes.
Mr. Eastep, you're a utilities analyst with the Public Service Commission, correct?
Correct.
And were you assigned to work on the 4 cases that we are in a hearing about here today?
Yes, I was.
Did you file direct testimony, 2 sets of direct testimony on August 21st? One set in the West Virginia American Water Company and Lashmeet PSD PC case, and the Lashmeet PSD CN case.
Yes.
That consisted of 12 pages of questions and answers. Is that correct?
Yes.
And on the same date, you filed direct testimony in the, for sake of brevity, I'll say the other 2 cases, the Water Company and New Haven cases.
Correct.
And that was also 12 pages of questions and answers.
Yes.
Do you have any additions, corrections, or comments you'd like to make on this time about your testimony?
No.
Okay, so everything in there is still accurate, and you would attest to it today as your direct testimony?
Yes.
Okay, thank you. Witness is available for cross-examination.
Mr. Callis.
Yes, thank you. Hello, Mr. Easton.
Hello?
You've sat through the hearing so far this morning.
Yes, correct.
Okay. I will try to shorthand things today, referencing some of the questions and answers you've already heard, and maybe we'll refer back to them if that's okay with you.
Yes.
Mr. Crislip, in his testimony to which you responded in yours, indicated that he thought that there were a number of, negative public policy outcomes that would be attendant to this new approach in the orders that brought us here. Are you familiar with that testimony?
Yes, I am.
I want to talk about a couple of those and get your impressions of them. Would you agree that in the past, when it comes to extending water and sewer service, that the commission and the staff and the consumer advocate especially have encouraged outcomes that would maximize the use of public funding, that is, grants and low-interest loans?
I wouldn't disagree with that.
And why do you think that staff and CAD and the commission have pushed that outcome?
Push the outcome of maximizing public funding?
Yes.
Just because it is a resource offered to public utilities in the state.
It's a public policy benefit to have that outcome be maximized.
Yes.
It puts less construction cost on ratepayers and effectively puts it on taxpayers, including taxpayers outside of the state.
Yes.
And keeps rates lower than they otherwise would be.
Yes.
In fact, when a project is being developed, an extension project by a public service district, it has to go to the IJDC. And one of the things it's trying to show the IJDC is that its project has attracted a lot of that public funding, and that makes the cost per customer lower than or the ultimate surcharge amount, if there is a surcharge, as low as it can be. Is that how you understand it?
I can't really speak to IJDC approval policy.
Have you ever been involved in any cases where IJDC funding approvals have been relevant?
I've been a part of cases that have been approved by the IJDC and filed for this commission as CN cases.
But you're not familiar with what the IJDC considers when it approves or disapproves a funding request?
I am not familiar with all of the specifics of what the IJDC looks at in their review.
Okay. Would you believe that a cost per customer evaluation is something they do look at?
I have no reason to disagree with you.
Okay. Does the staff, when reviewing certificate requests and projects that have been through the IJDC, look at cost per customer as something that's relevant?
I believe that is a part of the engineering division's review.
Do you know whether the staff, through its engineering division or otherwise, believes that, there is a point at which the cost per customer for an extension project becomes too high and unreasonable?
I am not aware of any cases where this commission staff has recommended disapproval of a case because of a cost per customer basis, but I am also not aware of any CN cases that have come forward in front of this commission, at least in my time here, involving private bank loans.
Okay.
At least not for public service districts.
Yeah. I would acknowledge that it's not something that's commonplace now. There was a time when it was, but not anymore. Since you brought it up, there's nothing that precludes any water provider for getting private financing for an extension project, is there?
Not that I'm aware of.
I asked Mr. Altizer if in that situation an entity would have to go to the IJDC for approval at all, and I'm not sure he knew the answer to that question. Do you know the answer to that question?
I do not.
All else equal, do you think that a change in policy at the commission that makes the company responsible for all the debt service of public partners in their extension projects would tend to make districts more likely or less likely to get the best public funding packages they could?
I can't speak to the behavior of the district.
There were a lot of questions that I had on redirect of Dr. Chard about Rule 7.5 and some of the questions that Chairman Lane asked of her about that rule. Are you familiar with that rule?
I reviewed it for the first time as part of this case.
Okay. Do you agree that it in fact applies to all water utilities?
Yes, all water rules, to my knowledge, apply to all.
And I had a number of questions of Dr. Chard about the different kinds of water utilities and different situations in which it might become relevant. Is that generally how you understand how the rule applies?
Yes.
And for water utilities, is it your also your understanding that it's not a discretionary thing? In other words, they are permitted to make the contribution to an extension that the rule specifies, but the party seeking the extension has to pay the balance.
Yes.
Is Rule 7.5 or the impact of it, the relevance of it, mentioned in any part of your testimony?
I did not mention it.
And why is that?
My focus of my testimony was on the cost impact of the surcharges and the benefits of cost sharing, as has been ordered by this commission in recent cases.
You mentioned the issue of fairness as well, did you not?
Yes.
And I take it it's your assessment that it would be unfair for customers to have to pay a surcharge in order to, in these situations, when the water company could finance the debt of the districts.
Not just that the water company could finance these debts. It's that these customers, these district customers, current and future, pay the water company's full rates, which include allocating a significant number of things to them that they don't directly benefit from.
Okay.
And so it would be only fair to them if they are receiving the same benefits of the water company's economies of scale.
Okay. But we're talking about customers that aren't customers of the districts or the company yet, right? When we're talking about customers who are asking for service. They're not paying any rate of the companies at this point.
Not currently. Not today.
And they wouldn't until they got service.
Correct.
And for all other situations but the ones we're just talking about in these cases, those customers would have to pay an amount that is measured by the degree to which the cost of the extension exceeds the Rule 0.75 amount, right?
Can you restate that question?
Yes, for all situations other than the ones we're talking about in this case, all other water utilities, all other extension requests by unserved parties, those parties would have to pay an amount that represents the cost of the extension less the utilities Rule 7.5 contribution amount.
I believe that's correct.
Okay. And do you think in all of those situations there's anything unfair about expecting the party seeking service to do that?
I have not really reviewed these other situations. I'm not familiar with like contractor development extensions that Dr. Chard talked about. I haven't really done it. Like, I don't have a position on fairness in those respects.
Is it not your sense, though, that embedded in Rule 7.5, which specifies that there should be a reasonable relationship between the impact on existing customers and the cost of the extension to the party seeking to be served, that fairness essentially is baked into that rule already? Is that how you understand it?
I don't have a reason to disagree with you.
Yeah. I mean, when you're talking about the commission developing a reasonable relationship and treating, parties similarly and fairly is what it's all about. Otherwise, it wouldn't be reasonable, right?
Right.
In her direct testimony and also in the petition for reconsideration in this case, Dr. Chard referenced a number of cases that this commission has decided, relatively recently, I mean, since you've been at the commission, that related to Rule 7.5 and its relationship to the company's contributions, required contributions.
Which, I'm sorry to interrupt you, which cases are you speaking of?
I'm talking about the ones that Dr. Chard referenced at pages page 5 of her direct testimony. Bates number 26.
Okay.
Did you review those cases, those decisions that have come, in the last 10 years, including some in 18 and 19, in your development of your position in this case?
I reviewed the 11-1451.
Okay, is that the only one?
Yes.
Okay. Did you reference any of these cases in your testimony or take on Dr. Chard's assessment of what they required of the company and how that related to Rule 7.5?
As you've asked me previously, no, I have not answered to the Rule 7.5 commitment.
During his testimony today, Mr. Crislip said at the outset that the company really is not involved in these projects until it gets the request for a contribution to them. Is that how you understand their development?
The company would be more familiar with that than me.
Okay. Do you have any sense of it at all?
I mean, that's my understanding of how it happens as well. But again, Mr. Crislip would be more understanding of how the company reviews these than I would be.
To be clear, the company does not specify or recommend or suggest a surcharge of any level to anyone. Is that correct?
I believe so.
In fact, it is the districts and their engineers and the county commissions that that supervise them and the customers seeking water who determine whether there's going to be a surcharge, and if so, how much.
I believe so.
Yeah. And if they didn't value water service enough to pay the surcharge, then presumably they would not seek to have one applied in order to get a project done.
I can't speak to their opinion on the surcharge.
Are you involved, or do you expect to be involved in the company's base rate case that's pending now?
I am involved.
Would you expect that in that base rate case, part of the staff position will be, as it has been in every case I've been involved with, that it's really important to make the company's rates as low as reasonably possible?
I don't see why staff would recommend anything other than that.
Yeah, and that would be the correct approach. Would you agree, though, that the responsibility to pay debt service in lieu of surcharges for public partners and their extension projects is going to have an upward impact on rates, all else equal?
Sure, the inclusion of these debt service payments will increase the water company's rates.
Do you have any sense of how many other public service districts are public partners of the company who might be looking at these cases and how they develop and making decisions on their next extension projects based on a ruling that the company would be required to pay all their debt service?
I know that the water company has other public-private partnerships, but I can't attest to their behavior in lieu of this order, in light of this order.
If the orders in this case were to stand and not be reconsidered as the company has asked, would you expect that those districts would be incentivized to design projects that the company would be responsible for paying for in a way that they have not previously been?
I don't know how to answer that question, Mr. Callis. The only thing I can say is I don't even know. Can you restate the question?
I'm not sure I can.
Okay.
Would you think that the orders would incentivize public partners who might have thought their projects were too expensive in the past to go ahead and propose them, since they know under the new arrangement the company's 167,000 other customers would be paying their debt service for them?
I mean, sure, but as I speak to in my testimony, single tariff pricing was, in the beginning, in addition to everything that Dr. Chard spoke to, also supposed to facilitate extensions to underserved and unserved areas.
The sense of that order was, would you agree, that the company would be in a better position financially and managerially and operationally through having a single tariff rather than 12 separate ones?
Right.
To run all aspects of its business, including extensions and acquisitions.
Correct.
And in that case, we weren't talking about, in the single tariff pricing approval, an extension to any particular new set of customers. We were talking about levelizing the rates as between all of the company's then separate districts who all had different rates.
Yes.
Going from multiple rates to a single tariff.
Yes.
You speak in your testimony to, to Dr. Chard's calculation of the rate impact, which she assumes, for purposes of that discussion, would be collected through the DSIC mechanism. Do you understand that?
Yes.
is it the staff's view that the district is the appropriate or best place to have and ensure recovery of the costs of public partner debt service to the extent these orders are not reconsidered?
I don't have a specific position on that, but I don't object to keeping it in the district.
Dr. Chard said that if it were in the district, she thought it would be appropriate that the portion of the district that would represent debt service for public partners not be applied against the current annual and aggregate caps that are present in the district. Do you agree with that position?
I'm not intricately familiar with the DISIC process. I have not been a part of any of the cases. I can't speak to staff's position on the DISIC cap with respect to these orders.
Okay. Would the same be true about her suggestion that there be some kind of annual limit or aggregate limit associated with the portion of the DISIC that would account for the payment of debt service for public partners? That you don't have a position on?
Staff does not have a position on that.
The company expressed a number of financial concerns in Dr. Chard's testimony, and one of those got discussed this morning, having to do with the difference between expenditures by the company for operation and maintenance versus capital expenditures. And Dr. Chard said that there was more value essentially to customers in expenditures for capital as opposed to O&M. Do you agree with that in concept?
Can you repeat that question?
Yes, Dr. Chard said that there was effectively more value to customers in company expenditures for capital than for O&M, and it tried to minimize its O&M expense and maximize capital expense. Do you agree with that principle in general?
I don't disagree with the principle.
And that's because I assume, for one of a number of reasons, when you are capitalizing dollars, then there's a flow of depreciation expense that comes back and gets used for customer benefit.
Sure.
And you can fund a lot more with in terms of what you're building with CapEx than you can with O&M expense.
Sure.
And if the company were building extensions of the kinds that Lashmeet and New Haven propose to build here, it would be capitalizing those and getting that benefit of making capital investment as opposed to O&M. Is that right?
Yes, I assume the water company would capitalize these.
Yes. It would have to, in fact.
Right.
But in the situation that's being proposed in the orders, all of the dollars that the company would be paying would be O&M, not capital at all. And customers wouldn't get the benefit that goes along with the company having made capital investments. Do you agree?
I would agree that the situations are different.
You indicate at pages roughly 6 to 8 of your testimony that the company's participation over the years in public-private partnerships has been beneficial financially to the company. Is that correct?
I believe I cited water company witness testimony where they say as much.
You have no reason to disagree with that.
Right.
I mean, you're expanding service to more customers. That's economically beneficial to everyone, isn't it?
Yes.
But it's not the company's reason why it filed a petition for reconsideration here is not based on its financial performance or expected damage to its financial performance. Is it because it's recovering all the money through the district?
No, but I included it because I thought it was relevant for this commission's consideration.
You acknowledge that it's really the company's concern for rate impact on its existing customers that drove it to make this filing, not a concern for its financial performance, assuming it gets timely recovery through the district.
The water company has and can state its own position.
Okay. That's fair. Have you made any independent inquiry with entities like the Water Development Authority or the Municipal Bond Commission or Bond Council for these kinds of projects to determine whether a company commitment to pay another borrower's debt service is going to be feasible or accepted to those entities?
I have not.
Do you think that might be a relevant inquiry in trying to advise the commission on whether what they've proposed in the orders is feasible at all?
Sure. Yes.
Mr. Callis?
Yes.
Have any of those entities filed an objection to our order?
No, none of them has.
Okay, thank you.
They are aware, I will tell you, at least one of them, quite aware that this situation is subject to reconsideration. Both of the company's witnesses, Mr. Estep, responded to the chairman's inquiry about alternatives here, and I think certainly Mr. Crislip and I believe also Dr. Chard said that expanding the number of people in a district that would be responsible for the payment of surcharges, including expanding the areas that are served by a district, would be ways to minimize, reduce the amount of surcharges for any given project over what it would otherwise be. Do you agree that that would be, if surcharges were to be retained, that that would be a beneficial approach?
Yes. A larger customer base to spread a surcharge over, should it choose to be retained, would lower the surcharge compared to what it would be based on the current customer count. The only thing I would add on top of that is that I have asked data requests in the CN and in the PC cases to try to look more into what kind of customers those could be in terms of water company customers in and around the district service territory, and I have not gotten an answer.
Which cases are those that you asked these questions in? The ones that we're
I asked during the original pendency of the CN cases, and then the current, like within this timeline since the reopening, I asked about water company customer count in the district service territory.
Okay. Going to ask that I approach the witness and distribute a document that I'll ask be marked as company cross-examination exhibit one. It may be mystery stuff that this is part of what you're referring to.
Thank you.
I'll represent for the record that these documents getting out. These represent a selection of the company's data responses from the staff in these, what I'll call two sets of dockets. Lashmeet staff number 1-01, 102, and 103. And then New Haven, the same numbers. I think they really are the same questions. A few minutes ago, Mr. Estep, you mentioned having asked a question about numbers of customers. Are these the responses that you were thinking of?
Yes, this is one of them. In addition to these, back, I believe it was last year at this point, during the original pendency of the CN cases, a data request with a similar question was asked of the district.
Okay, yeah, and the companies weren't involved at that point.
Correct.
Right, okay. The reason that I wanted to pass these out and talk to you about them is somewhat related to what you've just mentioned, but it goes more to a concern that was raised both in the jumping branch Nimitz case of a couple years ago that gets referenced in the orders in this case, and about which we heard some this morning. And that's customer erosion. The concern that when a unit of property is replaced under the O&M agreement, that somehow the effect of that, if there are customers that attach to it or were previously served by the replaced piece of property, is to erode the customer base over time. Are you familiar with the concern that the commission expressed on that point?
Yes, I am.
And would it be fair to say that these data requests, particularly numbers 1 and 2 in each case, were staff's, or maybe yours, certainly staff's effort to find out whether that erosion in fact had occurred?
Yes, but as can be seen here, the water company did not answer the data request itself because it only had customer data up to or back to 2013.
Okay, so you got an answer from 2013 on, but not before that.
Correct.
Okay. So when you said didn't get an answer, that's what you were talking about.
Correct.
Didn't get a full answer.
Didn't get the full answer.
Okay. In both cases, the response to 1-02 and for each district was that no district customers have been transferred to the water company from the district in either case during that entire time period. Is that accurate?
That is correct, but I believe that the water company answered in the jumping branch cases that customers were not transferred over time, but there were some customers that were transferred right at the time of enacting the agreement.
Yes, because of a project that was referenced in that case, but not because the water company had consistently over time eroded the customer base of the district, right?
That's what they attest to in the jumping branch case.
And you have no reason to think that's inaccurate.
Correct.
And likewise, in this case, you have no basis based on what the company has answered in its data responses presented here that there's been any erosion of either district's customer base as a result of the concerns that the commission expressed.
I have no reason to believe that customer erosion has occurred. However, in the company's response to Lashmeet 1-4, which is not included in this cross-examination exhibit, the company does attest to the fact that it has customers in the Lashmeet Public Service District's territory. And specifically, at least it has town of Matoka.
Okay. But that doesn't go to the erosion issue, just a different fact, right?
It does not go into the erosion issue.
So there's no factual support in any of these three districts, much less the two that we're talking about here, that kind of erosion that's been offered as a basis for changing the direction on how these things are paid for is present.
I would say that there is no support that customer erosion has happened since 2013.
That's fair. To eliminate the concern of potential customer erosion, do you think that it would be an acceptable approach to modify the O&M agreements to ensure that that does not occur? If we were to retain the surcharges, that is.
Can you state your question one more time?
Yes, if the commission asked for alternatives, as we've talked about before, if we were to retain, the commission were to retain, as the company has recommended, the surcharge-based, Rule 7.5 based arrangement for funding extensions, do you think that to alleviate whatever concern there is about customer erosion based on replacement of units of property, that it would be appropriate to amend the O&M agreements going forward to ensure that that worrisome provision is taken out and that concern is no longer present?
I have no objections to the removal of the provisions that lead towards the customer erosion concern. However, the only thing I would note is that the O&M agreement that was filed for approval in this case, which still includes the surcharge provision, does call for, in the termination of agreement, that upon termination, that these facilities would be conveyed to the water company anyway. So I do believe it wouldn't completely eliminate the issue.
That's a different concern, is it not?
No, I think it still discusses customer erosion. It calls for that if the district must either convey the facilities that it owns and that the water company is operating to the water company, or it must pay back the water company for its investment, which my understanding would include the district investment under 1-4 in both cases that is not part of this cross-examination exhibit.
Okay. Okay. Thank you for your time today, Mr. Eastep. I have no more questions.
Thank you.
Commissioner Larrick. Commissioner Rainey.
I have one question, Mr. Eastep. Good to see you this morning.
Good to see you.
In your testimony on page 10, starting at line 4, can you just amplify that a little bit, if you would? I think you probably answered all that in a series of questions that Mr. Callis answered, but I'm just curious about your thoughts there, that whether the current customers of the district are customers of the water company and how that applies to your perception of the surcharge.
Sure. There's been a longstanding principle that these customers, the district customers, although they are district customers, they are in all other aspects outside of the like on paper definition water company customers. And as water company customers, they participate in the water company's vision of economies of scale. That includes the DSIC. That includes now this wastewater allocation surcharge. They participate in the water company's vision of an economies of scale, but to turn around and have a specific surcharge applied to them would be to deny them of the same benefit of the economies of scale that they participate in.
Thank you. Mr. Eastep, all of the customers of the district, not just the new customers, are subject to the surcharge. Is that correct?
That is correct. And so looking at, I believe it is the New Haven case, for example, that $9 surcharge that that $9 surcharge is based on a customer count of the district's entire customer base.
And so as the case stands right now, or did the ALJ do a surcharge for Lashmeet of less than the 440?
Yes, I believe the Lashmeet surcharge that was approved was $2.66 per month.
And then the New Haven was 9.17.
That is correct.
Okay, thank you. Okay, I don't have any further questions of you. Thank you. You may, Mr. Head, do you have any redirect?
No, Your Honor, thank you.
I remembered. Thank you.
Your Honor, the company moves into evidence, cross-examination, Exhibit 1.
It may be moved into evidence. So, Mr. Hayes, you've traveled all the way down here to come to this hearing. Would you like to come up to the stand, be sworn, and tell us what your concerns are?
Sure, yes, ma'am.
You'll get to be on TV and everything.
I'm on TV.
Well, we stream these live, so all your friends out there will be watching you.
You look good. You're all right. I'm sure my book got more dapper on TV.
Okay, do you want to be sworn in?
Do you swear or affirm the testimony you're about to give this morning will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, why don't you state your name and spell it, please, for the record?
My name is Kenneth, Kenneth Hayes, Hayes, and I'm the chairman of the New Haven Public Service District.
Okay, so why don't you tell us what your concerns are?
The biggest concern is trying to serve the people that are still without water service in our area that have been anticipating water for over 30 years. I've actually been chairman of the district since 1982. And so most of my adult life has been spent in an effort to secure water some way. But we didn't have our first customer or our first monies available until after we entered into an O&M agreement with the water company. Our first project back in about 1991 or 2. The first money put towards our area was a small cities block grant approved by Governor Arch Moore just prior to leaving office. I don't remember what year that is. Somebody can Google that up, I think, and we'll know when we were,
About 1988.
88. Wow. Well, that's when the North Fed area started getting water. The big project was going to cover the entire northern part of Fayette County to the tunes of $20 million to do the entire area. We went to the Infrastructure Council to try to attain this funding, and we were very successful. They tapped about every possible avenue at that time, but it came up to $10 million. And in the last 30 years, we've spent trying to piece in the parts that got left out of the initial project. And we're continuing to do it. Naturally, when you get to where we are now, all the low-hanging fruit's been picked. And so now the cost per customer continues to rise. And when we first embarked on contracts 18 and 19 for some of these other rural areas, the grant funding wasn't enough to get what we needed. So we implemented a surcharge as a mechanism to get how much money we needed, which was going to have a loan payback. Well, with COVID and everything that's happened with that, the costs have increased such an astronomical amount that the surcharge that we deemed as being reasonable, honestly, is not that reasonable today. And so, but the people have attended our meetings, and they're hauling water in the back of a truck from a fill station at the Piggly Wiggly on Route 60. And they desperately need water. Between having no water and poor water, and they've been hearing the same story. It's coming, it's coming. And what else can I say to them than it's coming? It's closer than it ever was, but it's coming. And so the timelines have gotten, and these people, one guy made a comment in a public meeting, one of our meetings not that long ago. He said, "Hey, we pay $100 a month for television. I'll pay it for water." We're not looking at that much money, but that was the statement he made. And so the people are concerned that the more we football the process of getting approval to advertise, to get some backhoes out there digging water lines, it just time keeps dragging. And we do have some timelines connected with some of our funding that could easily go away if we can't start construction prior to December of 24. And this thing has continued to drag. You can see, you saw the years there. You can look at New Haven PSD's customer count. We haven't completed a project in a number of years, probably at least 2,000. Last project before these two went on board was a sewer project in Winona. And so it's probably 2015 since we did a water line project. So any of those customer increases you see there since then have been because of new development, people moving into our area, and not because we've been aggressively running water line extensions. So I've battled for years the concept of the customer base continually dwindles, but it's not the case in our area. It might be statewide, but it's not in Fayette County, West Virginia, in our area. People want to move there. It's a good place to live. Shoot, look at this. Got good neighbors. So anyway, I just want to say that
the people are willing to pay a surcharge. Even though I am completely supportive of spreading it around the 149,000 people, so everybody pays a quarter, as opposed to 1,900 and some customers paying $9. So I'll be glad to answer any questions.
Thank you, Mr. Hayes. Do any of the parties have questions?
No, Your Honor, thank you.
Mr. Head?
No, Your Honor.
Commissioner Larrick? Commissioner Rainey?
Well, we got 2 contracts right now that's going to serve roughly 150, 160 people. We've got 3 more extensions that we've already approved, and I gave the contractor documents that I signed last week, actually on Monday, securing we're moving forward with engineering work, even though we got these 2. Well, actually, as far as y'all know, we just got 1 because we haven't filed the other one yet, since we were kind of holding our breath to see what was going to happen out of this. But we have another contract that mirrors this one in the same generalized area that serves a lot of people. And our area is big. Basically, we are serving the unserved folks in Fayette County that aren't currently served by PSD or municipality. We've got water lines in Sun Mine, Dairy Hill area over next to Mount Hope and the Boy Scout Reserve. We've got a water line project just outside the city limits of Gully Bridge that's on one of our future contracts. And we go all the way through Lookout, all the way north up 19 to Miller Ridge Road and Sunday Road, and all the way south to the New River Gorge Rim. So we've got a pretty good size, and we got a water line that goes down Route 60 from Manstead to serve those folks that lived above the old golf course there at Hawks Nest, Persimmon Road. And no, we don't. We don't. Actually, I had to promise the mayor of Mount Hope that we weren't going to infringe on his territory, because he hoped to serve that place. So in order to get an AML project over there to Dairy Hill and Sun Mine, I had to tell him that we had no intentions on jumping in on any of his customer base. So anyway, and that, I'll just say, that was over a Subway sandwich. Yes, sir.
Okay, I don't have any further questions. Thank you, Mr. Hayes.
Thank you much.
Now, are there any other witnesses to come before the commission? Okay, I have a question of Mr. Callis. Explain to me why, if we entered an order on April the 14th in this case, construction has been delayed. The only part that is in question is how it's going to be paid for. And so why has construction been held up?
Well, Your Honor, they're not our contracts to let or not let, but, and we are not really involved in the funding packages that require closings before construction can ensue. But my guess would be that if a district doesn't know what the source of debt service for the funding that's going to support its loans is going to be, it can't close.
Yes, certainly.
It's almost like trying to hit a moving target with times and labor expenses going up, materials going up. Every time we go to an accountant to get a Schedule B, or what's that called, Rule 42 compiled to know what it's going to be, time just drags, and that changes by the time we submit paperwork. It's almost like the those things are obsolete by the time we're able to get them filed because of the environment that we're operating in these days. And it is what it is, and I just like to see something get arranged, worked out, so we could move forward with whichever funding scenario we've got to have.
Okay, thank you, Mr. Hayes. If there's nothing else to come before the commission, we are adjourned. Thank you.
Your Honor, before we adjourn, is there a briefing schedule we should know about so that we can conclude quickly for the commission's benefit?
I don't think we need any briefing. I mean, you said it pretty much in your petition and the testimony today, so I think we've got everything that we need to decide the case.
Thank you, Your Honor.
Thank you. This is off the record. There's a railroad display out in the lobby that I encourage you all to take a look at. Our railroad inspectors have put that together, and it was at the state fair, and so you all would find it interesting. Thank you.